The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, Attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. Hello. This is Stuart Address, and this is Ask a Lawyer for February 8th, 2019, the second show of our second year. So, we survived. Anyway, I hope you all had a nice week and are looking forward to a very good weekend. The weather seems to be getting a little bit better. Then again, it's much better compared to other parts of the country. So we should take solace in that. Although for me, I'd like to see some snow. Today, we're going to start with a little bit of interesting news. Over the course of the past year, I have discussed several times issues of sexual harassment, gender discrimination, and it seems that people don't learn. There is a auto dealership that I have had occasion to be involved in the last few years 3 times on sexual harassment cases, all of which ended up settling before we filed suit. And I got a call late last week from a high-level executive in that chain of dealerships that what I knew didn't scratch the surface. Now, I had suspected something of that nature, but of course I had no individual knowledge and no specific people coming forward. And I have now learned that we have a high-level executive of a major automobile dealership that is essentially nationwide that is aware of widespread, alleged, since we have to use that, sexual harassment, alleged gender discrimination that is rampant throughout the company, that has learned that there is a wide degree of fraud on consumers, allegedly, and fraud on manufacturers, on warranty work, and that it costs consumers and even manufacturers of automobiles who pay for warranty repairs quite a bit of money. One illustration is that according to the information that has been provided to me, there is a dealership that regularly takes in vehicles that need work on an engine and intentionally blow the engine so that they can file a warranty claim with the manufacturer for a blown engine, which gets it much, much, much more money in reimbursement than if they had just fixed the engine. Obviously, that is not exactly lawful, if that's what's happening. And the executive that I am referring to complained about a number of these practices and was fired earlier this week. Well, in the law, we call that whistleblowing retaliatory termination. So it seems as if, unless these folks are willing to come to the table to amicably negotiate a resolution of his claims and provide a severance package that is reasonable, given the termination and given the high-level nature of his work and what he was earning and what it will now take to find a similar position, particularly locally. And I don't mean locally here, I mean locally where he is located within Florida. We are going to have to take a different tact, and that will be to file suit in federal court for the federal claims that we believe we'll have, and also the state whistleblower claims, and also to go public Now, this is not exactly the going public because I haven't told you who he is, and I haven't told you the name of the dealership. And I've done that really because what we're talking about right now is ongoing sexual harassment, gender discrimination, things that we have talked about over the last year, that one would think that a company that has been involved in this and resolved some of these claims would have educated their personnel, and that HR, human resources, would be on top of things like this. But to learn that it is still ongoing and is rampant, well, you know, the appropriate plaintiff who that would happen to, that comes forward, may end up getting a lot of punitive damages as punishment to the dealership. But the news, if we have to go public, in addition to filing suit, I suspect will be, given the nature of who the dealership is and who's involved, extremely newsworthy. And I think the point here is for employers. Be careful. Follow the law. It's not that hard. If you have somebody within your company that is sexually harassing women, and by the way, men can be sexually harassed too, then deal with it. You know, the whole law, and we've discussed this, is that upon reporting of such a claim, it is the duty of the employer to engage in a thorough investigation and to take prompt remedial action if they determine it's appropriate. You know, if they do that, they're protected. They can't be sued, or at least they have a defense. So to fail to conduct such an investigation, to fail to take prompt remedial action, is what exposes the actual employer as opposed to the supervisor or the manager or whoever it is that's actually engaged in the sexual harassment. The same is true with gender discrimination, age discrimination, discrimination based on religion, national origin, disability, all of them. Once the employer has information that it is existing, the duty is to conduct an investigation and to take prompt remedial action. If it does so, according to the Supreme Court of the United States, it has an absolute defense to liability. Because if it didn't know it was happening and it fixed it once it learned, you can't sue the employer. Now, if you've been touched or something, you might be able to sue the person who did it for battery. That's a tort claim. But the employer is free and clear. So one would think the employer would stand up and take notice and do the right thing, but unfortunately, too often that doesn't happen. And more unfortunately, when you find a pattern of it occurring in a company, especially a company that is giant, I'll be blunt, the idiocy of that is beyond calculation. So we'll see what happens in the case in which I've now been retained, whether or not we are able to, since the individual has been terminated, negotiate a reasonable severance package, or whether they want us to file suit and go real public with names and ranks and serial numbers and all that good stuff. And we can do that here next week maybe. We might do that also on a wider level. So, with that being said, let's talk about a number of other topics, a smorgasbord, let's say. And sort of let's lead into different types of attorneys that I have encountered over the years, that you encounter whenever you have an attorney on the other side. And what is the impact upon the client? Now, I will admit that in my younger days, I was probably one or two of these types of attorneys we're going to talk about. I was a real SOB. In fact, I remember when I was practicing in New Jersey for a law firm that was relatively large and important in the state and had over 100 attorneys at the time. We had a litigation department meeting, and there were about 40 people that met in the litigation department in a conference room one day. And I had to report as a junior associate on a seminar I had attended on dealing with the SOB litigator. So it got to my turn during this meeting of the litigation department, and I started to speak, and I was interrupted by the chairman of the department, who happened to be a former New Jersey State Attorney General. And he says in a loud, booming voice, "Excuse me, you went where? What did you go? As an exhibit?" Yeah, ba-dum-bum. Yeah, that was my reputation.
I'm sitting here wondering why there's a seminar for that. I'm thinking, was it really titled that?
Yes, it was.
Okay.
Dealing with the SOB litigator, it was a seminar that tried to give you techniques to deal with difficult attorneys. And that is what they called it.
As an exhibit.
That's what they called it, yes. I have a note here that's not what I would call it, but I'm sorry, that's what the seminar was called. And they want to know if I went as an exhibit. All right, a fair comment then. I guess as you get older and wiser, you learn that I can be an SOB litigator. Oh, trust me.
Well, sometimes you have to be.
Exactly. And you do it when it's necessary. But I can also be a very collegial opponent, have a great relationship with my adversary, and fight when we have to fight, but not have it become personal where it starts to interfere with both clients. So let's sort of give a few examples. You can have two attorneys that face each other in a case that are pleasant and professional, that are able to talk to each other without yelling, that are able to make compromises, concessions, negotiate, and still, when you have to go into court on a motion or what have you, can be very adversarial. And the second the gavel comes down and the decision has been made, shake each other's hands, go down in the elevator together, and nobody's gloating. It's just whatever was decided, and, we'll do battle next time, and until then we'll work together as we move this case along. Obviously, that is the best type of relationship to have with an attorney on the other side. I sort of now adopt the attitude of one free bite. By the way, that isn't the law on dogs anymore. We had a week that we talked about that. But I adopt the one free bite. I'll let somebody else demonstrate once that they want to be a SOB. And then I will go into that mode as well. It doesn't help the client, either client. In fact, it runs the attorney's fees bills way up. And it's unfortunate, but sometimes you're forced to fight fire with fire, or to try to teach somebody, let's go back to a more collegial relationship, because if you want to show me, okay, I'm going to be a little bit, if you want to show me, I'm going to be discreet. If you want to show me your vim and vigor, I'll show you I have a lot more of it. You all know what I'm talking about.
Bring it, right?
Yeah, bring it. And it gets the juices flowing. I mean, it's not that I don't enjoy it anymore. It's that I've learned that, A, it is harmful to the client to be that way if you don't have to be that way.
But see, that comes with your experience.
It does. And I've also learned that taking that type of personality home is not a very good and effective thing in life.
Well, every business, you should leave your work at work.
Not always. You take work home. You take work home to do work at home.
Well,
you take work home to discuss it, and if you're doing something that you're proud of, if you're helping the underdog, if it is not only a case that is, hopefully paying you money if it's a contingency fee, but that you're really trying to do right, there are certain things you may not be able to tell a significant other because of attorney-client privilege,
Sure.
but you could discuss the general nature of things, and yeah, you can take it home, but you have to take it home in the right frame of mind. And that's a lesson you learn in time. Now, another type of relationship is where you have attorneys that are difficult, caustic, antagonistic, but it only deals with the case.
Is that their style?
For a lot of people, it is.
Okay.
For me in the early years, it was. I didn't have another style. I didn't have another gear. That's all I knew. It was my personality. I can go there easily now. Sometimes I'll enjoy it. But I will tell you, to be there all the time is exhausting. I cannot tell you the pleasure of having a phone call with opposing counsel where we actually work things out. And I don't mean necessarily the whole case. I mean, I file a motion to compel discovery. I want you to answer these interrogatories. I don't like your objections. Give me these documents. And you have a phone conference and go through them one by one, and I concede a little bit, he concedes a little bit, or she concedes a little bit. At the end of the conference, you have an agreement. So you don't have to have a hearing in front of the judge. Or, if you do, instead of 30 items to fight about, you got 3. Because you can't fix everything. I mean, and you still got to represent your client. So some things can't be resolved. And that's the nature of the adversarial process. But that second type, the only benefit of the second type of relationship, other than the first, is that the nastiness is respect only to the case. But it's all the time. It's not just, you can't get along.
So it's every case.
Well, with that attorney,
yes. No matter what, no matter what it's about. Yes. It could be about puppies, and it wouldn't be nice, right?
There are a couple of attorneys I am dealing with right now that probably increase the fees to the client by a factor of double. And if a client comes to me, let's say they've already been sued.
Is it because they argue every little thing, and every little thing takes longer?
Yeah, it's that, but it's not just that. It's that they will argue every little thing, even if they know they're wrong, because they know how long it will take me to get a hearing and how much that will work against getting the case resolved quickly.
I have to ask you, are they running up the bill?
Well, some of them are, okay, look.
Maybe.
Look, not all of them. Some of them are just figuring, let's wear them out.
Because I'm thinking that person didn't pick a very good lawyer then, did they?
I agree. That's what I believe. Some of them, truthfully, yeah, they're running up the bill.
Okay.
Absolutely. Just like in any profession where people cheat, well, the good joke is, the law firm Dewey, Cheatham, and Howe. Well, yes, there are attorneys that run up the bill. And if you happen to get one of those folks and you figure it out early, get away quickly. Quickly. Because the amount of money it'll cost you in the long run, and who knows if the job will even get done right, even for the money you pay. But yeah, I mean, there are those that it's just their only gear. There are those that use it as a tactic. There are those that use it as a obfuscation delay mechanism.
That's what I'm going to have to look up. Say it again.
Obfuscation.
Okay, that one I don't know.
It's an extraordinary extent of delay.
Okay.
It's sort of what I don't know what goes on in Washington these days. And it does not help the client. But when you have somebody on the other side who just doesn't care, then on my end, I have no choice. I've got to be what's a good synonym? I've got to have a big bat. But it's not really a bat I'm talking about. Now, what's the third type? Okay, the third type we sort of already talked about. It's the type that you'd like. It's not somebody who's a pushover. There are some attorneys like that too. I love them. I love it. I can't lie.
Do you think they're in the wrong business?
Yeah.
Okay.
But that's not
Because
really.
I'm thinking I don't want the attorney that's
No.
a pushover.
No.
I'd like the attorney that's like a bulldog.
Hey, speaking of Bulldog, I haven't heard from him for so long.
What a segue there.
That's a great segue. No, but yeah, the best relationship is, well, first of all, it helps if you know the attorney and you've established some relationship that has trust, credibility. You know, that helps. But you know, if I get a call, as is often the case, either I write a demand letter, or I file a lawsuit, or somebody files a lawsuit against my client, or sends me a demand letter, and it's some attorney from some giant Florida law firm or Atlanta or wherever, because it happens, and they don't know me at all, and they see, oh, he's a solo practitioner, let's paper him to death. And they are obnoxious. They learn very quickly. Don't try it. Because I don't care if you got 10 attorneys on your case. I'll paper you to death. And that's my attitude. That's the bulldog. That's the SOB. I'll put in overtime hours and I will paper you to death. But that's not the relationship we're talking about. The relationship we're talking about is where, let's say I get a call from somebody who doesn't know me from Adam. And it's a nasty case. I mean, it's either it's been filed or it's been threatened to be filed, but you can tell it's going to be a nasty case. And the phone call is very pleasant, cooperative. Let's work on getting this pretrial order prepared. Let's work on figuring out how we're going to handle the discovery process. Let's coordinate these depositions. You can take that one first, but then on these types, I want to take this one first. And throughout the entire case, when there is a disagreement, it's a phone call. And even if they disagree, even if they can't say yes, it's done professionally and pleasantly. And so I can then say, and sometimes they say it to me, it's not just me saying it to them. Well, I'm going to have to file a motion, and we're going to have to let the judge decide that. But it's said not as a threat, as a nasty. It said, okay, we tried.
Well, that is the process.
That's the process. We tried. We could not resolve this point. So, a motion's coming. I'll give you some advance notice, and then we'll work to set up a hearing. You go to court on the motion. Oh my goodness, you could be fighting like cats and dogs. You could be even implying that the other is an SOB, and that they have no right to claim this, and they know they have no right to claim this, and they're just doing this for improper motives, and oh, it's nasty. And the second it's done, the volume comes down. And you're chit-chatting, the best situation, you go to lunch and you solve the case, Those cases are beneficial to the clients. A, because the attorney's fees are lower, much lower. And B, because they, more often than not, lead to a quicker resolution. More than 90% of all cases are settled before trial. Otherwise, a civil litigation process would never end. It's bad enough as
I'm
it
sitting
is.
here kind of feeling sorry for the judge because they basically have to be a referee because you guys are on your
Look
game.
at the synonym of the word judge.
Yeah.
Of course they're a referee. Absolutely. Referee. That's what a judge is.
Yeah, they don't get to be a part of that whole professional getting along part of it.
Oh,
They just
usually
get
they were, and now they're a judge. Judges.
They know how it used to be.
Some of them forget very quickly. Yeah, some of them forget very quickly, and are not very nice to litigators. But some of them are really great. And when you have a relationship like that with opposing counsel, whether you knew them or you didn't know them, I mean, I'm giving a great example because it's true. I mean, they're in Atlanta, and the firm they have a local office, but I'm dealing with some attorney in Atlanta. And you're able to work things out most of the time the clients, both of them, benefit. And it makes it so much easier to come to a settlement when the egos of the two attorneys have not been engaged. Let the clients hate each other. Let the attorneys do their job. And not, I mean, you want to win, but if you're settling the case, if you can let your ego disappear, because all you're looking for is a decent settlement for your client, and they're looking for the same on the other side, it is so much easier to settle the case. But when your ego gets engaged as well, as often happens, it is harder for a settlement to occur. It is harder for you to give the appropriate dispassionate advice to your client as to what's a good deal and what's not a good deal, because your competitive juices are going too, and you want to beat them into 6 feet under. Those things don't help clients. Now, I've been practicing, oh gosh, it's 2019. Soon it'll be 34 years. I don't feel that old. God, I hate to say 34 years. I feel like I should be in a walker or something. But a lot changes over that time. People change over that time. And I like the relationships, especially the local ones, where you get along with each other. You can go to the trial lawyer's luncheon and see your adversary, shake hands, chuckle over a couple jokes, and then the next day be in court yelling and screaming at each other. And having the judge yell at both of you, behave yourselves. Okay. Yeah, that's a warrior doing battle against another warrior. That's a litigator battling against another litigator, and doing it in the appropriate venue, which is in the courtroom, not outside. You know, you'd be surprised how many people come into my office wanting to change attorneys. And it's really because one of the big reasons is their attorney is it's typically because they're an SOB and they feel that it's costing them more money. And then I tell them I can't guarantee them I won't be the same, because I don't know how I'll be until I see who I'm dealing with. And then if I see certain names on the other side, I tell them, look, unless you want to settle this case, it's going to cost you. Because everything I ask for, objection, motion to compel. Objection, motion to compel. Over and over and over again. Expensive. Wish there was a better way. I like to say our system is the best in the world. I truly believe that. There's a lot of room for improvement. And that's one of them. Because when civil litigators can't get into a judge for 2 months, because there's only 1 or 2 circuit civil judges, because all the judges we have to be devoted to criminal and domestic and drug court, all because of constitutional issues. Well, civil litigators doesn't care if it takes 10 years to go to trial. So you get 1 or 2 judges assigned if you're in a size of a county like we are here. You know, Miami has more, and Fort Lauderdale, West Palm.
But then they have more cases too.
They do, and so people. Sometimes you find you have the same problem.
Sure.
Yeah. It's a problem with the system, you know. So what happens, you know, we talked about problems with your own attorney. You know, people come into my office, like I say, wanting to change attorneys. You know, my attorney won't communicate with me. I can't get a hold of my attorney. I'm only allowed to speak to the paralegal. These are things of concern. Shouldn't be that way. You know, it's one thing, you know, if the paralegal is the gatekeeper, you know, the one to try to answer most questions and refer to the attorney when it's necessary. You know, I try to tell people who sign up in my office that, you know, you're probably going to deal first with Cheryl. But if you need to talk to me, tell her. You'll talk to me. Or I'll call you back. Or we'll set up a telephone conference. Or send me an email, because If I can answer the email really simply, quickly, I can answer in 30 seconds or 3 in the morning. But you'll get your answer. You know, if it's more complicated, well, we may have to set up a telephone conference, or we may have to set up a conference in the office. But you have the right to have access to your own attorney, not just the paraprofessionals. But you also have to respect the paraprofessionals, because they have a job they're capable of doing, and you need to let them do it. And sometimes we have to have discussions with our own clients as to, this is how things work. And so don't be insulted because, you know, Cheryl tries to resolve your issue before you ever get to talk to me. That should happen most of the time.
Yeah, but that is her job.
That is her job. And you should be thrilled, particularly if it's an hourly case. You should be thrilled Cheryl's answering your question, because she's charging you a third of what I'll charge you if I have to have a telephone conference with you. Now, if it's a contingency case, well, then I'm trying to guard my time so that I can put it where it's most effective. But the good thing about being a solo practitioner is you don't take so many cases that you're overwhelmed, and I wouldn't either. I never wanted to work that way. I'd rather have a life balance than, you know, be as rich as Trump and never see any of my family, or never have my family want to see me.
That's okay. The gifts keep coming, right?
Yeah. You know, but I have a certain number of cases that I know I can handle effectively, and I know I can deal with the clients on a personal level. And it doesn't matter whether it's me as a solo practitioner or you're dealing with an attorney in a 200 attorney law firm. When you need to speak to your attorney, when you need the advice about strategy, tactics, what should I do? Okay, that's not something an attorney can simply tell the paralegal to tell you. You know, that's something that requires follow-up questions. It's a conversation. And for a conversation, you should have the ability to speak to your attorney. So when people come into my office, you know, I want to get rid of my attorney. I haven't been able to talk to them for 6 months.
Things don't happen very quickly, though. And there is probably time between we have this information to give to the client, and then now we're waiting for this. And I think maybe the clients are they're not feeling as though they're getting the
that is
attention.
True.
But there isn't anything new to tell.
Good example, okay? I don't always take a case when a client comes in, they want to get rid of their attorney. Now, I guess there are other attorneys who would just grab them up. I'm not saying I'm holier than thou, but I don't do it. If it sounds as if the person in my office is the one who's wrong, that they don't understand the process well enough, maybe the attorney didn't explain it properly, maybe they've never been involved in litigation, then look, for the consultation fee they paid me, I'll try to explain maybe why they haven't heard from their attorney, and maybe how you should let your attorney know that on occasion you need to hear from them, and it's what you expect, and it's what you're entitled to, but that it may not be that, you know, the attorney is keeping you out of the loop, and it may not even be Utah 0 degrees. You know, I envy you. Invite me on one of your trips, please. It may not be that the attorney doesn't care. It may just be that nothing's happening.
Right.
Now, the truth is, you know, I tell clients, on contingency cases, I don't send out monthly invoices. But on hourly cases, obviously, I do. And I tell clients on those hourly cases, you may get an invoice one month that could be thousands and thousands and thousands of dollars. Okay, I gave one to a current client for 2 weeks in January. That was $9,500. Very busy 2 weeks. And I tell them the next month you may get an invoice that's $150. Why? Because if we've set up depositions, if we sent out the interrogatories, document requests for admissions, now we wait. We wait the 30, 35 days for the response to be due. And if there's a request for an extension, usually you're going to say yes because the court's going to say yes a couple times. So we wait another 15, 20 days We're now approaching 2 months since we did this thing. And then we get a response that is, let's say, full of objections. Okay, now we're going to do a few things. We're going to write a letter. We're probably going to have a telephone conference with the other attorney. We may start drafting a motion. So now, in month 3, you may get another bill, not as high as the first one, but higher than the second one, which was $150. Mm-hmm. And we try to explain to clients up front, this is the way the litigation process works. It ebbs and it flows. And be happy in the month you don't get a bill from me. And, okay, call me very upset when you get this horrible bill from me, and we'll go through it. You know, I had a client just, today's Friday, Wednesday. Okay. Got a large invoice from me for the month of January. And this is a client that does review these invoices line by line, and that is good. Because you want to know something? If there's a mistake, if you accidentally put in another client's matter into their time, because, you know, keystrokes, mm-hmm. let them catch it quickly. Because I'll fix it. But, you know, mm-hmm. she looked at it, she called up, she talked to Cheryl. Cheryl said, well, you've got a client that has a few questions about the invoice and isn't really happy. They weren't expecting this size of an invoice this month. All right, so we had a telephone conference. Cheryl didn't have a telephone mm-hmm. conference. We had a telephone conference. Okay? And we went through her concerns line by line. And there weren't a ton of them, but we went through each one line by line. Some of them I explained to her, and she was okay with. Several, I said, I'll give you credit. Okay? Either she's right, and you just need to take that time off, or, all right, maybe she's not right, but it's not worth it to have mm-hmm. an unhappy client. So you do it. It's business.
Right.
Unfortunately, mm-hmm. law is business too. And when the client understands how things work in litigation, what to expect, why there's a lot of activity, no activity, moderate activity, tons of activity, especially if it's an hourly case, because they want a budget too. Then you end up having a client that is more satisfied. I won't say happier, because I don't know if I'd be happy paying some of these bills, but more satisfied, and at least understands the process enough that they're not angry at you. They may be angry that, why can't we get this document? Why is it taking so long? You give the answer, and they're not happy, but at least they understand. So when some clients will come into my office and be railing against their attorney, and I can hear that it's normal litigation and it's probably not the attorney. You know, Cheryl might pull up the docket sheet, and I'll look to see what's going on in the case. Is it like the attorney's done nothing for 6 months? Or is what I would normally expect to see in a court docket sheet, is that the flow of a civil litigation case? If it is, I say, look, you need to have a heart-to-heart with your attorney. Here's what the issues are. Here's why, you may not have a reason to be so upset, but you have a reason to understand. And if you have that heart-to-heart and you feel better about it, wonderful. If you have that heart-to-heart and you still don't like your attorney, come on back. I'll be happy to take your case. Because another thing clients don't realize, a lot of clients don't realize, you sign an agreement, fee agreement, a contingency fee agreement, an hourly agreement. Mm-hmm. You have the right to fire your attorney at any time. Anytime. You're the client. Now, you might have to pay the attorney for the services it's already performed, or in a contingency case, the attorney may have a lien if you hire another attorney against the proceeds of a settlement or a judgment.
For the time they put
in.
in.
So that the court could determine what is the reasonable value of their time, mm-hmm. and determine an appropriate amount if we can't agree on what will be paid. But you have the right to leave your attorney at any time. And there are clients that I take on, there are clients that I don't take on, but that have been dissatisfied with attorneys for so long. I say, well, why have you waited so long? Well, one thing, or I didn't think, or I wasn't sure, or they told me, or okay. You have the right. You can either do it yourself. It could be a one-line email. You're fired. Or you hire me, or you hire, Bill Smith, and, that attorney sends a letter to your attorney saying, we now represent, Jane Doe, and, we have the authority to advise you that you have been discharged. Please make a copy of your file as expeditiously as possible so that we can review the file and move forward in the matter. That kind of thing.
Do they do that?
Usually, yes.
Okay.
And when they don't, the next piece of advice to that client is send a grievance to the Florida Bar. Mm-hmm. They'll wake up very, very fast. Very fast.
Mm-hmm. What I like is you say the client and attorney relationship.
Yeah.
And it becomes a relationship because of how lengthy the process can be.
Even if it's a brief process. For the client's sake, hopefully it is a brief process, and it ends with them being very happy very quickly.
I would think everybody would be happy.
Well, sure, except the people maybe that paying the money.
There's always the other side.
But if it works out that way, my goodness, the client is probably, if they ever need legal services again, you're going to get a call, and we do. Mm-hmm. And they're going to be telling all their friends, which is the best referral that any attorney or any professional can get, is word of mouth. A lot cheaper than advertising in a newspaper or a billboard.
But not nearly as fun as doing a radio show.
No, it's not nearly as fun as doing a radio show. Oh, my goodness. I love having the forum to speak here. And sometimes when things happen in the world, like I remember the episode we did after the Stoneman Douglas shooting. Mm-hmm. That we did on the gun control and the Second Amendment. It's nice, to have a platform that they say, the framers of the Constitution, created the First Amendment, free speech. They talked about the marketplace of ideas and how even abhorrent speech should be permitted, because when you match the abhorrent speech with the opposing speech, the feeling was that truth will eventually win out, and the abhorrent speech will be reduced to what it deserves to be reduced to. And it's the conflict of different ideas. Now, that includes especially political discourse. As much as I have strong feelings about the current administration, it is the current administration. I was discussing just yesterday with the rabbi who's coming in. If I were to meet President Trump, would I tell him everything I think? No. It would be disrespectful. Not to him. I don't care about him. It would be disrespectful to the office of the President of the United States. Mm-hmm. So you meet the guy, I would be respectful. I'm not giving him respect. He may think I am, but I'm not giving him the respect. I'm respecting the office because it's important. And it's been damaged, in my opinion, but it's important. And the whole concept of political discourse is you should be able to share these competing ideas and values, maybe even loudly, but not the way they're being shared today. Not even the way they're being shared on the cable news stations that I like to watch, MSNBC and CNN, where they do the same thing. You get into yelling and screaming arguments. Nobody can be heard over the other person who's trying to talk. That is not the marketplace of ideas. Now, I agree. I can interrupt as well as the other person. It's instinct. But sometimes somebody has the right to say, let me finish. And they have the right to finish. And then you have the right to be heard. That's a debate. And that leads us around full circle to the Lincoln Park Academy speech and debate team, where you're teaching these kids to speak out on topics that compel them, that interest them, that make them excited or angry. Talk out. Say your piece. Now, in speech, that's a little bit easier because you're the only one doing it. In debate, where there are rules and the first person gets 5 minutes to speak and then you get 2 minutes of cross-examination and all this stuff, it's a little bit harder.
Do they learn to let the other side speak?
They have to because
now,
they have to.
This is now you see what's wrong with the TV news.
Yeah.
They never learned.
That's my point. That's my point.
Yeah.
That it is devolved into chaos.
When you go back years, though, it was there.
Yes. Look, CNN has Republican conservative commentators on there as well. MSNBC does. I don't really know if Fox has people that are more liberal because I don't watch it.
Yeah, they do.
But,
But Fox itself has become more liberal.
Yeah, in this case, yes, that's true too. That's amazing. But there are some of these Republican strategists and political commentators that I will listen to on CNN or MSNBC, and I'm impressed.
Do you catch the news ever on BBC?
Very rarely.
I like to because they have no bias.
Yeah, they have a different perspective.
Yeah, they do.
Those bloody Americans. Now, they should have just stayed in the crown.
We have no class compared
Right.
to them. I mean, they really think we're children.
I like the way we do it too. No, there are people that I listen to on the stations I listen to that are from the other side of the aisle that make a lot of sense if they're allowed to speak. Now, I may not agree with them on every issue, but I can hear an issue and say, oh, wow, that makes sense. If I can hear them. If the Democrat on the other side is yelling and screaming and I can't even hear them, oh, it's a fun entertainment show, but news? No. No. That's the whole point of the marketplace of ideas. Maybe you'll actually persuade somebody. And if you do, now you've got a convert to your position. And that is the whole point of the First Amendment. And we lose sight of that when we try to stifle speech we don't like. Even horrible, hateful speech. And, there are the great examples of it that, African Americans, Ku Klux Klan, Jews, Nazis. I'm sorry, in college and in law school, I tried to write a paper trying to argue as to why, within the bounds of our Constitution, we could stop certain types of speech that wasn't just negative, but close to inciting riot, which is against the law. Mm-hmm. And in college, I tried and I failed, but it was still a good paper. I got an A. In law school, I asked a professor in advanced constitutional law, I said, look, I did this in college. You're not supposed to really recycle a paper. I said, but can I try this again? I said, got the okay. Now I have a little bit more knowledge. I have more resources to research. I came to the same conclusion. I couldn't do it. How could I create a test that the Supreme Court could actually implement that wouldn't be subjective? What speech was I going to stop? The whole point of speech is you can punish it. If it incites riot, you can punish it. If it's defamatory, you can punish it. But you can't stop it before it happens. Now, when is there an exception? Okay, if you're about to say where our troops are and what day they'll be attacking because somehow you got a leak, no. That's legitimate national security, and so they're gonna slap you down, and there'll be a prior restraint of speech. But it's so rare that is permitted under our Constitution. So rare. It almost doesn't even bear talking about. So, I don't even remember how we got onto this, but in the little bit of time I have left, let me go back to the debate issue because I really think it's important. I have heard, since I've started really working with these kids this year, of programs in other counties further south where they teach speech and debate starting in middle school, elementary school, high school. It's a class. We may have a class next year here too. Wonderful. We have a principal that's in favor of it. They got to figure out how to work it out. I even know somebody who teaches debate to her first graders. First graders. What are they going to debate about? I don't know, cookies and milk.
Toys.
Yeah, toys. Hey, that's a good thing.
Toys.
But what's the point? The point is teaching them to argue with each other using arguments, logic, points, and not screaming and yelling over each other and listening to each other. And if you could teach that young, then maybe when they get into Congress, things will really be different. Now, I've said before, we have such a large crop of new members of the House of Representatives that are younger. I can only hope that they influence the dialogue in Washington now. That they can move the system a little bit. Because what we're doing now isn't working, and it's not what we did in the past. Oh, we fought in the past. I hate to say I'm old enough.
Yeah, but in the past, people were more like it was for the common good of all, not for just the good of me.
Yes,
and we've gotten to be a society where it's all about me.
You're right, but even in the good old days of yore, people wanted what they wanted for themselves, and a congressman from, Des Moines, Iowa, wants what he wants for his constituents.
Well, he's got to go back home.
Right. Hopefully has an eye on the country, but certainly wants what's best for his constituents.
Mm-hmm.
Okay. But there wasn't the same antagonism towards the other party, the same disdain for talking to them or even working with them. And again, another show we did, after Senator McCain passed away, he was a model of being able to work with the other side and to come to bipartisan pieces of legislation that were common sense. Didn't always agree with them, but he worked with a lot of people on the other side. And we need a heck of a lot more of them right now. So, in the 1 minute I have left, we didn't get very far in my little notes here today, but I hope you found it interesting about the different types of attorneys and the different types of relationships, because it's important. Have a wonderful weekend. We'll see you next Friday. This is Stuart Address, and my office is 781-8003. And Cheryl is there waiting for your calls. Have a great weekend. Take care.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.